Father, we thank you for the privilege of gathering in this place to consider your people's business. We thank you for the children who have joined us and their teachers and today. We pray, Lord Jesus, that the business and matters to be discussed will be guided by you and your honor and the benefit of Jamaica. In the name of Jesus, amen.
Thank you so much. Let me join with you, member, to welcome all our boys and girls from Creighton Primary. We have 27 students here today and 3 teachers, and they're all the way from Irish Town. Welcome to Parliament. Yes. Welcome to Parliament. Today is a joint select committee meeting, so it's not the regular meeting of Parliament that happens on a Tuesday, but we hope that the deliberations of today will also be meaningful to you because it touches on the education sector. So welcome again to Parliament, and I hope this experience will be a good one for you. All right, we have some apologies for absence from Member Morgan, Member Brown-Burke, and Member Hamilton. So we'll move to the confirmation of the minutes of the meeting held on Thursday, May 16, 2024. And you should have the minutes, and we'll begin with page 1 of 10. We'll move to page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. And finally, page 10. May I ask for confirmation of the minutes if there are no amendments to the minutes? Approved by Member Gale. Second? I guess
I second it.
All right, thank you. Thank you, Member Cuthbert, and welcome to all our members, those online and in the chambers. Welcome to our technical team as well. It's online today, our officer of the Office of the Parliamentary Councils, OPC, Mrs. Sherland, is online as well. Normally she's in the Parliament with us. Okay, she'll be joining us online, duly corrected by Mr. Nash. All right. All right, we'll move to any matters arising from the minutes. All right, if you look at page 2 of your minutes, there are some matters arising. Mrs. Gordon-Jones highlighted that the issues to be addressed by the technical team included the matter related to the decision on roles and functions of the board and the council, the transitional provisions for persons currently in the educational sector without an authorization to teach. She indicated that based on the discussion at the last meeting, the recommendation was for persons who would not be applying for a license to teach to get the time to apply for an authorization to teach, similarly to those who would get the time to apply for their license to teach. Senator Gale sought clarification on whether there was an authorization to teach for persons currently in the early childhood sector, and Mrs. Gordon-Jones stated that these were the persons referenced. The committee agreed to allow the technical team additional time to treat with the matters highlighted. So I want to ask the technical team if they are ready to speak to this matter. No, not yet. All right, our technical team is not ready yet today, so we will move on to where we left off the last time, which is, I think, the last clause that we did was clause 71. All right, members, there are some decisions to be taken at this meeting. Well, they were proffered at the last meeting, but we had to defer them to this meeting. All right. All right. So the items to be considered at this meeting are the following. Starting, okay, I don't have to read all of them. All right. They're not ready. All right, members, I direct your attention to page 7, fourth paragraph. The title is subclause 49.3, and it was a decision. Well, it says the committee deferred discussion on the matter to a later date. Oh, you want to go ahead and okay. Yes, clause 48, subclause 49.3.
Chair, good afternoon, Chair, members and colleagues online. I recall this specific provision. I think Mr. Foreman did not remember at the time his reason for the comment that he had made in relation to that clause. So I'm not sure if his memory is refreshed now to address same.
Mr. Foreman?
Good afternoon, Chairman and members. I think it might be helpful to complete going through the report and then dealing with all of these things at the back end. This particular comment was made in reference to a clause that we have not reached as yet. So I think depending on what the status of that clause is will impact on explaining the comment that was initially made.
All right, so noted. We'll move on to matters arising on page 8, second paragraph. The committee agreed to return to the concern raised by Senator Gale. Senator Gale, do you want to just recap again with that concern?
This was the one that I was referring to going forward, question of a disciplinary action. And I was querying whether under the definition of disciplinary action would be the imposed sanction as opposed to the activity to go to hearing. What is being suggested here in the, and this, let me try and go back. This was clause 50, was it? Right. So I was querying whether the position taken in terms of the pursuance of a disciplinary action would have been the resultant effect as opposed to the activity that would have been ensued when the complaint would have been presented. In my mind, the disciplinary action is the result. And I would want to ascertain what the definition of disciplinary action as construed would have been. Bearing in mind that I believe that there is no definition in the bill that spoke to disciplinary action, was there? I queried it because oftentimes if you activate the procedure itself in terms of conducting the investigation and conducting the hearing, and if in this case you were to use the term disciplinary action, someone who is accused or their representative might assume that disciplinary action would have already been taken. And the disciplinary action, in my mind, would have been the resultant of going through the procedures, and a determination would have been made. And
As was indicated in the previous meeting, Chair, the reference to disciplinary action based on its reference in the bill would be the activity that would be undertaken in relation to the discipline of the relevant teacher. And so, as similarly referenced in the education regulations, where under regulation 56, which speaks to where a complaint is received by the board and they think that disciplinary action ought to be taken against the teacher, they refer the matter to the personnel committee. So it's not the result of what is done, but it's the activity leading to that result.
In that regulation, it defines disciplinary action? No, it doesn't. It's only the term is used. Maybe for an abundance of caution, we might want to determine a definition. It may be the same way that someone misinterprets the use of the term suspension, where there was a suspension not being a disciplinary action, but you suspend someone from service to conduct an investigation. And the use of the term suspension sometimes is interpreted as the sanction imposed. I'm just saying that we might want to examine where the use of the term disciplinary action is so defined to be clear in someone's mind that it is not the sanction that is being imposed, but the procedure being implemented.
Can I see 50? 50 is the one.
Yeah, but I don't know. It's not in this.
Sorry, that is the clause 50.
Members, I think you have to go on microphone for those online to hear us.
Is someone speaking, Minister? I'm not hearing anything.
It says, upon receipt of a complaint, the council shall refer the matter to either the Professional Practice and Conduct Committee, PPC, the board of the relevant public education institution, or any other employer of the licensed teacher or instructor. 1. Where the matter is referred to the PPC should either refer the complaint to an independent investigator for investigation or proceed to conduct a disciplinary inquiry. That's an action. Where the matter is referred to the board or other employer, the board or other employer should take disciplinary action. And if the complaint is not heard and the decision handed down within 6 months of the referral, the council shall refer the matter to the PPC for inquiry. It is the use of the term should take disciplinary action that can be misrepresented and may, in fact, give and instruct that the board or the employer can take disciplinary action without going through the procedure itself. You're looking at this?
I'm looking at the
Page?
the revised draft based on the recommendations that were made. If I have the most recent, but I'm not seeing where any reference to that term has been made. So it's just a matter
in
of
the proposed draft.
Right. So, it's
So
just a
the
matter
question
of the
is,
report.
how did it find itself as a construct in the report to be represented that way?
Yes. I guess maybe it's just based on the summary that is outlined here.
Okay.
I don't think it would be an issue to change the wording to ensure that the report
I'm going, since I can't find it now in terms of the draft, so I will take your word for it that what is contained in that don't give guidance to that kind of representation. But again, Chair, I will look back at it just to be sure.
Inside the court, Supreme Court in downtown Kingston, the judge has taken her seat. Listeners, here's what we have. The grounds for the application.
Minister Green, I don't know if you're meant to be on speaker.
Sorry, deprived of liberty to serving any sentence.
Are you making an intervention, Member Green?
City, there's no lawful reason for the applicant's continued.
Member Green, please mute your microphone. All right.
My microphone was muted, Chair. It's not me. Sorry.
Member Green, do you have an intervention?
No, Chair.
Thanks. Mrs. Gordon-Jones, may we continue? So is it that you're saying you will ensure?
Mrs. Gordon-Jones would have pointed me to the amended version of the draft. I just can't find it in this bungle right now. I'm guided by her satisfaction that it's not contained in the redraft. I will just have to review that myself, but I won't hold us the proceedings because of that.
All right. And just some housekeeping, members. Going from clause 43 last time, I would just like for members to ratify the decisions of the committee at last week's meetings. There were a number of clauses and subclauses that were accepted. Clause 42, subclause 43 2B1, clause 44, subclauses 45, 4A and B, subclause 46, 5, clause 47, clause 48, so members, I put it to you to ratify the committee decisions to accept the draft recommendations in the report.
I so move, Chair. Yes.
Do we have a second?
I'll second, Minister.
Thank you. All right, we'll move on to subclause 49.3. The committee deferred discussion on this matter to a later date. Member Miller read that the committee noted the concern for the lack of consistency in the time frames between subclauses 49.3 and 61.4, which related to the same topic. He read the committee's draft recommendations to amend the subclause to prescribe a time frame of 7 days. He read Mr. Foreman's comment, which highlighted the decision to delete subclause 61.4 and suggested for the committee's consideration the deletion of subclause 49.3. Dr. Gordon explained that a statement was made in the past discussion from the chambers that there is a public service regulation concerning a similar matter which should be used instead of the current recommendation. I'm going to ask our technical persons just to refresh our minds as to what that was. I read subclause 49.3 on page 7 of the minutes.
So, Chair, as you have read in the minutes, I recall that there was the inconsistency in the days that the time frame given for the return of the license. However, I think the clause was thereafter deleted, and so the issue was whether, I remember Mr. Foreman was, in its comment, asked whether we are to delete that clause as well. Section, clause 49.3. So 61.4 spoke about the return of the license. And 49.3 had a similar provision, but 61.4 was thereafter deleted. And so I think Dr. Gordon had a different view in terms of whether or not the person should return the license. She was of the view that it should be returned.
Even though all the information will be available electronically and they'll be able to check.
Thank you, Chair. Good afternoon, members. The license that is given to the person is a license that ought to be returned, and we keep that position, that it should be returned to the agency once the person's license has been suspended or revoked.
What that means is that the council would take possession of the license for safekeeping in the case of suspension, and if it's revoked, you still take possession of it. Not if you cancel a passport and it's cancelled. But in the case of, and I can understand the suspension because you don't want that teacher to still be in the possession of the license and to be practicing. So in this case, it would be the teacher to hand over the license.
Just to note, though, member, that the clause which is referenced here is in relation to revocation, not suspension. Revocation of the license, not suspension. So the license has been revoked.
Use the term suspension and revocation in her response to it. What the suspension? I'm just assuming that what Dr. Gordon would be saying is that you're suspended, so you ought not to be using the license. Right. Until the matter goes through and that teacher gets it back in their possession. What you don't want, I'm assuming that what you don't want is a situation where that teacher operating under a suspended license would be tempted to utilize it. I know, Senator Braham, if you have a suspended driver's license, that would be recorded somewhere, and if you're caught in use of a suspended license, then that's a different matter with the authorities.
It's the same thing. But it will be recorded at the council if your license is suspended or revoked.
All right. So if in this situation you'd be caught using or operating as a teacher with a suspended license, then that other area of the legislation that constitutes a fraudulent activity would be triggered. I'm just trying to tie up the enforcement mechanisms.
And also to point out, member, that this, if the person doesn't return within the time frame, there is a penalty. The person is a summary conviction.
Right.
SG had her hand up, Dr. Gordon.
Yes, thank you. I'm unable to use the camera. I apologize. But the issue is a bigger issue. You have basically the same provision in 61.4, which the committee deliberated on and decided to remove it. So you had basically two provisions saying very much the same thing. The committee took a decision to remove it from 61.4. So I'm not clear on the rationale to keep it in 49 if you already decided to remove it from 61.4. I think that is the bigger issue. It was an inconsistent decision which needs to be rectified. I don't know if perhaps someone can go back to the minutes of that meeting to see why the committee took that decision at the time. But that decision was taken. And
on that particular point, under
It was a revocation.
61.4.
It said
However,
basically the same thing. It said the same thing. I can read it. 61
61.4,
says,
yes.
yes, it said, a person whose license is revoked shall within 7 days of the date of the revocation surrender the license and every copy thereof to the council. And the committee deliberated on that provision and decided to delete it.
The concern we have, SG, I know time changes things. The concern we have is that if that physical license is not returned to the council, then we will need to have a process to identify if our teachers here are teaching without the license, or if they use it abroad, because the council has a link to other countries in terms of our accreditation of our teachers. And we don't want somebody who has been suspended in Jamaica or whose license has been revoked to go into a foreign country and is able to use the license.
So I'm not discussing the merits for or against, I'm pointing out that the matter was discussed by the committee and the committee took a decision, because that is my role, to remind the committee of something like that. So is it that the committee is now reconsidering the matter and is deciding that this provision should be retained, and it should be retained in both places?
Well, I would like to bring it back to the table, because since then, we have established relationships with councils in the UK, Canada, and the United States, or similar bodies. So once a license is suspended or revoked, the physical license should be returned to the council.
Minutes as to why the committee decided to revoke that.
All right, we will check. We will pause on this one and check.
And just to be clear, is Dr. Jones asking the committee to revisit this particular clause now based on new information?
You have to turn on the microphone.
What's the new information?
No, she just made reference to the fact that in review of other legislations. That's what you said?
Think with other bodies. We are now a body that has established ourselves as the body that provides teachers with the professional standing to other bodies in other countries, similar bodies in other countries when they go to get employment abroad. So we don't want to be in a position where we are tracking anybody to find out if they're using the license that was suspended or revoked. We would like the license to be returned. If the person wants to be fraudulent and make a license, okay, but we don't want to have that responsibility to be tracking somebody whose license has been suspended or revoked.
Chair, the fact that the record would have shown that this particular clause was withdrawn may have been either a recommendation or a deliberation, and Member Braham is correct for us to check the minutes to make that determination. Because we would have, the committee, I must say, would have deliberated on it and may have been presented with a recommendation so to do, to have agreed.
I did not have the information I'm giving you today.
And so that's why I asked the question for the record. Are you presenting new information to the committee and asking us to review and revise the position that we're taking then? Can you, Dr. Jones, sorry, Dr. Gordon, maybe I'm speaking in the...
Member, we just have to check the minutes.
Please.
Yeah, we will check.
But there are two things at play. In the first instance, Chair, the committee would have deliberated and taken a decision based on the outcome of those deliberations to have deleted the clause. And now, what is being presented is the assumption of some new information that may have been sitting somewhere for us to be revisiting the clause.
But we need to go back.
Yeah, first.
Right.
First.
All right.
Primary.
All right. All right. So we'll move on to the next item. All right, the next item is on page 8, the very last paragraph. And this has to do with clause 50. Sorry, before we get there, there's some other recommendations for us to ratify. And those would be on page 8, starting at, the chair indicated that the words "is not" in code should be inserted between the words "decision handed down" in the last sentence of the draft recommendation. So starting there and moving all the way through to the end of page 8. On to page 9, clause 65. So we need ratification, members, for the acceptance of the recommendations in the draft report. Up to clause 65 on page 9. Up to, yeah. So we're starting from page 8, paragraph 3 from the top, and then all the way through to page 9, clause 65. It's ratification for the recommendations. The last one, it says clause 65, yes. So the committee would have accepted the draft recommendations, but we need for them to be ratified today. You were here. You were here.
Only one who was here. For the record, since we had accepted it when we were here.
No, that we are not here.
I am proposing to ratify.
And based on what my colleague has said, I will second. I was saying that based on what my colleague has said, I will second.
Did we get you on microphone, Senator? No? You? Okay, good. Thank you. Thank you, Member Braham. All right, we'll move on to clause 66 on page 9. And this is a decision that the committee agreed that we would finalize at this meeting, which would have been our well, at this meeting. So clause 66, it says, Member Miller read that the committee did not recommend any changes to the clause. He read the comments from Mr. Foreman for the committee to consider an amendment to include a reference to decisions taken by the PPCC to make it clear that such decisions can be appealed at the appeal tribunal. Mr. Foreman explained that the comment was made in consideration of a decision for the PPCC to be the entity charged with conducting disciplinary proceedings under the bill. Mrs. Gordon-Jones sought clarification on whether the proposal was for its replacement with the council or as an addition, and Mr. Foreman confirmed the latter. All right, committee members, I'm going to recommit page 8, the last paragraph. Sorry, it looks like we went right over this, but the committee had deferred the deliberation on the draft recommendation here, pending Member Braham being back and having read this one. So Member Braham, page 8.
So this body, which is a disciplinary, not a disciplinary, it's a regulatory body. So let us, for example, say that I'm a young attorney that has been brought before the regulatory body for attorneys. And consequent on their decision, I am not suspended. There's no automatic right that my employer must pay me. You see, it's a matter of government policy. The government is who is going to pay most of this, all of this, if not, except for the private schools. But it seems, why I was concerned is that if the regulator is carrying out its own investigation and take its own time to do whatever it's doing, then the employer, which would be ex-prep school or ex-basic school, should turn around now and be responsible for the costs of that time when the teacher has been suspended or the teacher was not able to work. And I've always been wondering if, while the government can hug it up, it is not a fault of the private school or even the government school. Who should bear the cost? Based upon an investigation and action being taken by the independent regulator. And that is the philosophical question that we have to resolve. Clearly, the policy is that the employer must bear it regardless. And if that's the policy, then so be it. Although I don't know that it is a good policy.
Understand Member Braille very well. However, the engagement of a teacher in a private institution is normally through contracts. And so the institutions, knowing the regulation or requirements on the law, would need to structure their contracts so that if the person is not performing, and there, of course, the contract can be terminated. They're working a different situation. And so, while I understand you, I must say so far I've never had an issue with a private school. But I understand your concern, but the private schools, the private institutions can protect themselves such that if the teacher is not performing, there's a termination clause.
Yes. Seems so. Seems so. Thank you. There are one or two scenarios. Scenario number one, the teacher is alleged to have misconducted herself. Or himself. No, that's her. During, while at school or relating to school activities. And that's the matter that the personnel committee or the board may have been interested in. And if it is that the board takes action and it turns out that the teacher should not have been suspended and so on, then naturally the board would expect that it must reinstate the teacher and pay salaries lost. That's fine. But we are talking about when the regulator takes action. It's not the regulator you're talking about?
Disqualifying offense, so the person has been charged and it go to the remit of the court.
That's right. And so it is not the regulator, it's even worse now. It is the authorities responsible for the criminal law. And in that situation, because the person has been acquitted, the private institution should find the money to pay for the 5 years that matter has been, or 10 years that the matter has been going on. It's not a quick process, you know. It's not the school's fault. Why in this legislation are we saying that they have to pay? Now I can understand the government feeling that it should pay because the government is a welfare entity and so on. But why should the private individual or the private school after 5 years of going through the system, pay a salary for 5 years. That is, for an institution, that is a borderline profitability institution. It could be bankruptcy. So I did ask us to look at the policy and see if this is an obligation we really would like to impose upon a school. The teacher was accused of committing a criminal offense. And during that time, the teacher has been out of work. I'm sorry about that, I really am. It turns out that the teacher is acquitted after 5 years. It is not the school who suspended the teacher. Well, it may be the school having regard to the charge. Is it proper that the private institution should pay? Because I put the government institution on one hand and a private institution on another. And I mean, the fact that I can think about it means that it can happen. So it's a matter that we should, is it something we should say here or just leave it alone?
No, we didn't. And so, Member Braham, we were waiting for your return since you had raised it. But two things are at play. So the contemplation is how to be fair to the teacher, but you also have to balance and be fair to the institution. Now, in terms of what control a school may have and a council may have, that is definitive because the bill, in terms of going through the procedures, have some timelines in treating with it. The disqualifying offense now takes it to a different remit where it's a different jurisdiction that is dealing with that neither the school nor the council have any control. And so I can understand what Member Braham is saying, that where you have no control over those timelines, it would be viewed as being unfair to bind the institution to paying for that. I can understand that. So maybe we need to confine it in terms of where the internal mechanism is applicable. Yeah? If a teacher, if the outcome of the hearing finds in favor of the teacher, then treat with it. But where the jurisdictions and the remit is outside of the control of the procedures now, and that rests entirely with the courts, then I wouldn't go there. That is my suggestion for some sort of a balanced approach. If it's internal, then because the internal mechanism has some control over the time frame. But when it gets to now a higher level where this would have been triggered by a disqualifying offense, and that is now under the remit of the courts, that can take some extraordinary different time frame, then we may not want to compel an institution to take up that cost.
Mrs. Gordon-Jones, what happens currently? I know we don't have the disqualifying offense, but okay. But I know that there's an appeals process, but it's more internal than external.
There is no provision under the regulations to treat with a situation where a teacher is brought before the court and the matter is being treated with. There is currently no such provision. What happens now is sometimes the teacher might go on special leave with or without pay based on the approval of the minister, or they go on what we call administrative suspension, which will also still allow them to get full salary until the matter is determined. So there is that gap in the system, which is currently being treated with now under this bill.
But there is no reference that would have escalated it to the level of a disqualifying offense to be treated with the courts, as it is now. Right. So I don't think we're ready to get there so yet then.
The experience, limited as it is, when the school takes an action, and let us say that the school dismissed the teacher consequent on its process, and it is found to have been wrong by the appeals tribunal or the court subsequently, the school fits the bill or foots the bill in that situation and pays and is required to pay because they should have, otherwise they would have been in their job and so on. But this is an external situation. The school can't do anything to ensure the speed or lack of speed and so on. But it is not a matter, it's a matter that we make up our mind. If we want to impose the cost, we impose the cost. Because the teacher, on the other hand, will be saying that they should be paid. But what I'm saying is that in other disciplinary scenarios, there's no provision for payment. The lawyer don't get no pay.
So members are saying because of the nature of this being outside of the control of the council, the JTC, that, and the school, that we do not at this moment prescribe any payment. Mrs. Gordon-Jones? Right, so that would be the decision, that no payment be set out.
Sorry, Chair?
Yes, go ahead.
Right. So just to clarify, so the provision in the revised draft that was the subject of the discussion, the present discussion, is the part that says the teacher whose registration, license, or authorization to teach was suspended shall be entitled to the full amount of the salary which that person would have received if that person had not been suspended. Just for clarification, the committee's decision is that that clause should be removed.
Okay.
All right, let me rephrase that. Is the committee's decision that that clause should be removed?
So just to add to Mr. Foreman's statement there, or question, there are two instances. You have an instance where the teacher is charged with a disqualifying offense, and by virtue of that, is the license or authorization to teach is suspended, and if that person is acquitted, then they will be entitled to the full amount of salary which they would have received. However, you also have the situation where the person is convicted and then further appeal the matter, and the matter is quashed or overturned on appeal. Then that's where the money comes in as well. So it's two situations. So the committee needs to consider.
Me that if we're going to pay one, we should just pay all. Because I think both of them are unreasonable. But if that's a view, and I'm saying it's probably no wrong or right here. We have to decide who's going to bear the cost. There are three persons who could bear the cost. The teacher, and we may decide that it's not appropriate for the teacher to bear that cost. The state, that is to say, the government pays the cost for the government school plus any other school. Or the third option, the government bears its costs and the operator of the private school pay the 10 years for the absent teacher. Now, for the government, it's not a problem, but for the private school, it is. And it is a problem in both situations, because both of them, the school would not have had anything to do with it. Anyhow,
So
and that's why I had recommended, Minister, from the last many months ago, that the ministry sit down and consider this matter from a policy point of view. That's what I had said. I remember it like night for the day.
Chair.
Go ahead, Mr. Foreman.
If Senator Abraham would permit me just add one factor to what he's said, on the side of whether it's a problem for the government or not might be a consideration that affects the country's finances and whatever amounts are set aside for these types of eventualities. So it may or may not be the case that it's perfectly fine for the state. Taxpayers might have a view on that.
All right. What we'll do, I'll confer with our technical persons at the ministry and come back with a policy decision on this. Is that okay? That's fine, Senator? Member? Yeah. All right, good. All right, so let's carry on with the ratification. Continuing on clause 66. This is a decision that we said would be finalized at this meeting. Clause 66, Member Miller read that the committee did not recommend any changes to the clause. You read the comment from Mr. Foreman for the committee to consider an amendment to include a reference to decisions taken by the PBCJ to make it clear that such decisions can be appealed at the appeal tribunal. Mr. Foreman explained that the comment was made in consideration of a decision for the PBCJ to be the entity charged with conducting disciplinary proceedings under the bill. Mrs. Gordon-Jones sought clarification on whether the proposal was for its replacement with the council or as an addition, and Mr. Foreman confirmed the latter. So Ms. Gordon-Jones, you want to shed any further light on this and refresh our memories?
So under clause 66, you currently have that a person is aggrieved by a decision of the council or a disciplinary decision taken by the board of an educational institution or any other employer of a licensed teacher or an instructor may appeal to the tribunal against the decision within 28 days of being notified of a decision of the council or the employer of the licensed teacher or instructor, as the case may be. So based on the fact that the PBCJ is now taking a decision in relation to the teacher, as well as their situation where the council will be taking a decision, for example, in not granting a license, as well as the board of an educational institution or another employer the proposal made by Mr. Foreman is to indicate under this clause PPCC as well.
One thing, there are two things I want to say. One is a question. The PPP entity you just mentioned, right, is an investigatory entity, am I correct?
No.
Remind me what it is.
It carries out the disciplinary inquiry.
Okay. All right.
And makes a recommendation.
And then makes a recommendation.
No, it makes a decision.
But I noticed, for example, that we have put in here that you can appeal a decision of a board of education, of an education institution. There is an appeal process under the Education Act.
It's been repealed.
In respect, it has been repealed.
In relation, under this, yes.
I see. So all of that appealing to the appeals tribunal set up at the ministry would be done away with.
So this is the same appeals tribunal under this bill.
Very well.
And to note that the tribunal is currently at the JTC.
The new one will have, what, 5 persons, if I recall correctly, versus 3. Yeah.
Tribunals, they are not adequately remunerated. And because of that, the enthusiasm, properly, as I use the word adequately, as stipend and so forth, to buy a little coffee is not enough.
I agree with you, member, and there should be budget space to adequately compensate members of the appeal tribunal. Yes. Yes, they have to be compensated for their skill. Okay. Okay.
Member, adequate amount
Member
might be
Go ahead, Member Miller.
the member adequate amount might be a lump sum for little me or persons who sit on the tribunal.
They're paid per sitting member, Member Miller. All right, let's move on to subclause 671A, starting.
Excuse me, Chair. Just
Okay,
wanted
please
to know
go
what
ahead.
the decision. Just wanted to know what the decision is. That it will be amended or not.
So I take it that this is to include the council, the PPC, and other employer of the licensed teacher or instructor. So that's the amendment.
Okay, so I just wanted it to be, I didn't know what the decision was.
No, it wasn't, you're quite right, SG. It was not made clear.
Okay.
So, I wouldn't want to use the word perturb, but the appeal entity, the appeals entity to which the PPC decisions can be appealed to, the board of schools can be appealed to, right? Also applies to privately run institutions. But why would we do that? Why would we set up a system for the, you see, I understand that the government institution could want to have an appeals process and that sort of thing, and it always did, and it could well be a part of collective agreement 30, 40 years ago, why we was established. But you have a private institution, they have their board, they carry out their function. Those persons are very likely entitled to go to the Ministry of Labor and the Industrial Disputes Tribunal. Why would we want to impose this process on them? Unless I'm wrong. And Ms. Jones, you could tell me, am I wrong? It applies to private schools? It sounds as if I'm batting for private schools, but it seems to me a problem.
If based on what Member Braham had raised, Dr. Gordon, based on what Member Braham had raised, Clause 4B speaks to, Clause 4 speaks to who the act applies to. And B speaks to a person who teaches in a school, whether in a public educational institution or in an independent school. Does the independent school include private? Yes. So, for clarity, is Member Braham asking us to amend 4B? I wouldn't think so. But based on what he's saying, if it's applicable to them, and we're speaking about going all through the procedures leading up to an appeal, then it would be applicable to them.
Chairman, I accept that the system is designed to license teachers wherever they are. They must come under the regulation, right? But I'm talking about now circumstances where the school decide internally to take an action against its staff member for whatever, misconduct and so on, the private school. At the moment, the private school doesn't have to come to the Ministry of Education to approve its decision whether to terminate or don't terminate a teacher. The teacher then can use the Industrial Disputes Tribunal or the Ministry of Labor to deal with his or her matters. And so that's why I'm asking you. I am not dealing with regulatory standards, whether you're entitled to get your license or not. Those are separate issues. But you get a job with my basic school, John Brown Basic School, and I went through whatever my process is, and I take an action which may result in termination. It turns out to be the wrong action. I didn't have a hearing, I was unfair, etc. Then you appeal from my little board now to the big committee. Why do you want to take on that responsibility? Is it your business? I don't know. Unless I'm wrong, so tell me if I'm wrong.
Just to remind Member Braham that the complaint that is being treated with is in relation to that which would have been made pursuant to clause 50. So I'm just checking to ensure that there is no conflict in terms of the jurisdiction of a private school as against the council itself.
Based on what Member Braham would have complained about, and in part 7 starts with complaint, clause 50. It means all of clause 7, 8, and 8, he's asking for the private schools to be exempted.
No, but the thing is, this provision is in relation to
because it flows, you know. It has to start from a complaint. And a complaint triggers the investigation and the disciplinary inquiry. I'm just trying to understand, because you spoke of the question of including them, and I start from clause 4 to where the act covers in terms of also independent schools. But then, based on what he has raised, outside of the registration and the licensing, there are parts that deals with complaints being made against the teacher or tutor or instructor in the private institutions that would also compel the investigation to take place and the disciplinary action. And I'm asking whether or not you're suggesting that all those areas should exempt the independent schools.
My comment is limited to employee-employer relations. So matters dealing with regulation, whether you're properly qualified for a license and all of those issues, those are not matters for the board. Those are for this regulator. But if a teacher was insubordinate and an action is taken because of that alleged insubordination, that appeal goes to this regulator. Could you tell me, show me the section that deals with it again, please? It's 66, is it?
Would that be a choice as to which appeal board that teacher goes to? Could they use the process of the JTC or the process that exists at their school?
Based on what we have here, the decision of the aggrieved person and the action that they would want the appeal that would be taking place in terms of the decision of the private school here. Based on the scheme of the bill, it was not contemplated in relation to what Member Braham is saying about in-house situation of a private school. It would be in relation to those complaints made as a result of clause 50, which treats with if the registered teachers fail to comply with a condition, they have contravened the professional standards under section 10. They are not a fit and proper person with section 34, or they have failed to comply with the provision of the act, or they are, as the new provision is inserted, convicted or charged with a disqualifying offense in Jamaica or outside of Jamaica. So Member Braham has raised an important point, I think, for us to ensure that we are not overlapping jurisdiction in the primary school for normal situation, whereas in the public schools now it provides that if it is that a complaint is made against a teacher, and that that board would have to treat with that disciplinary matter. I am seeing here where we also have that reference to the other employer. If there's a complaint made against the board, to the board of that employer, that it is to notify the council of the complaint, and there are some other provisions that flow. This is in the new draft.
Clause 50, because as I understand it, 66 says a person who is aggrieved by a decision of the council or a disciplinary decision taken by the board of an educational institution or other employer of a licensed teacher or an instructor may appeal to the tribunal against the decision within 28 days of being notified, or the other employer of the licensed teacher or instructor, as the case may be. And then section 50 says, a person who alleges that a registered teacher, licensed teacher, or an instructor, one, has failed to comply with conditions imposed on registration as a teacher, that's a regulatory function, has contravened any of the professional standard, in my view, that's a regulatory function, is not fit and proper to teach, a regulatory standard, has contravened or failed to comply with a provision of this act, be the equivalent of the registration license of a teacher or authorization to teach of an instructor has been suspended or revoked by overseas authority, may make a complaint in writing in the prescribed manner to the council setting out the details of the alleged contravention. So it is based on that, as I understand it, a decision is made by an entity and there's a right to appeal. There may be an overlap, because when I am taking disciplinary action in my local school, whether private or public, it may be that I discover that the teacher has fallen before professional standards in terms of her behavior. And that is a matter that the regulator will be interested in. But to the extent that it affects the school, the internal school would wish to investigate that and bring that conduct to an end, whether by termination, suspension, or otherwise. I am saying, for the private school that was not under the regime of appeal, they should not be brought under the regime of appeal. Or is it a deliberate decision now that we are going to clog up the system with these private schools every time they take an action? They are now going to appeal to the regulator and the disciplinary committee of the regulator? No, but if I'm wrong, tell me that I'm wrong. Why in 66 you say of a board of an educational institution, if the board takes an action, at this time the public school board takes an action, there is a statutory right of appeal. And we cannot take that away, and I'm not saying you have to take it away. So it's going to continue under this new regime. But in relation to private institution, there is no statutory right of appeal dealing with any tribunal, committee, or anything. The teacher is dealt with in normal industrial relations situation and move on. If there is a professional issue that the regulator wants to deal with, it can deal with it separately. Why, somebody tell me, anyhow, I'm actually just repeating myself, and I don't think there's any benefit in that. One of those persons online, Mr. Foreman, one of those persons could chime in and express a view. Maybe this is all nonsense.
No, sorry. Chairman?
Please go ahead, Mr. Foreman.
Right. The view I'll express is that it's a policy choice. I think I agree with Mr. Graham's analysis that the effect of the bill as originally drafted and as as now stated in the redrafted provisions would expand what now exists to allow teachers who face disciplinary actions in the private sector to be able to approach this particular tribunal. And that would be a shift insofar as it means that those private teachers, instead of addressing their grievances perhaps through the tribunal that is the IDT, would now have to address it through the tribunal that is under the teaching council regime. So that's a policy choice. Subject to what my boss might want to say, I don't think from our perspective any legal considerations need to be advanced in respect of this particular point. I assume that the policy intention was to streamline the teaching profession on a whole, whether it's public or private, and by having by having the appellate tribunal be able to address matters in both public and private sectors, that streamlining objective is achieved. That's my assumption regarding the policy intent. But the ministry can say whether that is the intention or not.
These private schools are private businesses. Can avail themselves of the Labor Relations Tribunal.
And we must concern ourselves with overreach. Not only overreach, but we must concern ourselves as to whether the system has the capacity for the additional work that we are taking on. Now, I regret to say that it hardly has the capacity for the work it has now, much less to go and take on every teacher and every person from every other school. That is an internal matter. If it is a policy consideration, I ask us to properly and really look at it.
As far as I know, that's not the policy of the ministry. Members, I do not believe that that was our intention to incorporate the private institutions. So members saying, I don't believe that was our intention.
We would have to review the proposed legislation to see where any other amendments would be made, should be made to align itself with what Member Braham has suggested.
Just to be clear though, Minister, because I don't want to hear that I was proposing that teachers in private institutions should not come under the regulation. Yes, but I am making it very clear that teachers in private institutions should be regulated and licensed like every other teacher. Fine. But if it is that I'm working with Cavan, Gale and Company, attorneys at law, and the partner, Mr. Gill, choose to fire his associate, Mr. Braham, do I then go to the General Legal Counsel and ask them to adjudicate on the firing of Braham? If there is a regulatory matter to be dealt with, that can be dealt with separately. But if there's an industrial relations thing, then it's still like that. I take Mr. Attorney Gale to the Ministry of Labor and sort it out. Or sue him. No, you'll be even richer. Remember the BIT, you have property, you know. And it is getting more and more.
So based on the draft that I am looking at here of the proposed provisions, it's October 2023. I think that was the most recent one received from Mrs. Sherland. I must say that I'm seeing, based on what Member Gale had indicated before, that there is reference to disciplinary action under the new clause 51, and it's in relation to any other employer of the licensed teacher. Dr. Gordon and I were just discussing, based on Member Graham's intervention, under clause 51.3, it currently provides that where a complaint which is referred by the council to the board of a public educational institution or any other employer of a licensed teacher or instructor pursuant to subsection 1 is not heard on a decision handed down by the board of that public educational institution or any other employer of the licensed teacher or instructor within 6 months of the referral, the council shall refer the matter to the PBCJ for inquiry. So what this is saying is, if it is that the council refers the matter to the private employer in this case, and it's not treated within 6 months, then the council shall refer the matter to the PBCJ for action. But these complaints are in relation to those received under clause 50. So in relation to the reference to the private employer under clause 66, based on the discussion, we are proposing that it be removed, because it would, as Member Graham indicated, seem as if we are going to be treating with appeal from the private school that is not in relation to the scheme of this bill. Other employer.
Sorry, excuse me, Chair. What exactly is to be removed? Because I thought it would be, if the ministry is saying that the current situation is to continue, you're not going to remove the clause. What you would do is tailor it to only refer to public educational institution.
No, not the clause.
Sorry, SG. I spoke off the mic a while ago in seeking that clarity, in that it ought not to remove the entire clause, but to remove other employer.
No, but it's not just that. It says board of an educational institution. You need to modify what you're talking about when you say an educational institution, because an educational institution covers both public and private. Right, so the issue isn't just or other employer.
So where it is now, where a complaint which is referred by the council to the board of a public institution.
Right, that's what I'm saying.
Right, or any other employer.
Right.
Well, I think you're right, where you would remove or other employer,
right,
but you also need to modify educational institution as well.
Yes, we'd have to insert public. Mm-hmm. No, it doesn't say public under 66. It doesn't.
So is it supposed to also refer to the PBCJ, which was the other question Mr. Foreman had raised? because they are a decision-making body.
SG is referring to the inclusion of the PBCC as was proposed. I don't recall if the committee...
No, I don't think we proposed. I think we asked the question.
Very well.
I think we had agreed earlier on in this meeting to include the PBCC.
So then I would ask, is it all decisions coming out of the PBCC? Because is it both public and private teachers of public and private institutions that can go before the PBCC?
Well, I mean, that is going to find that one would have to review the legislation, but the PPPC, I believe, is confined to consider professional matters under the Act. It doesn't have any remit into the running of the school, does it? But one would have to review it, and if it does touch, you would have to pare it down as well.
Chair, I'm looking at the redrafted clauses. I don't see any distinction. I see that the PBCC can deal with all teachers. Doesn't matter where the teacher is posted, whether in a private or a public institution. And so it would mean if the PBCC took a decision to suspend or revoke a license of a teacher, well, I'm wondering if I'm correct.
SG, but
maybe it's public, I don't know.
My understanding, and that's why I was saying, SG, that the regulator deals with all teachers in relation to their professional standard and all of that. And so if you're a private teacher and it wishes to investigate matters like that, that's fine. It can do that. But what I'm talking about is where a decision was taken to terminate whatever discipline a teacher at the local level, whether that should be subject to an appeal. So I suspect that the PPC might be able to carry on as is because it is dealing with general regulatory issues as against individual localized industrial relation matters. But it's a matter for a review.
Okay, understood. Thank you, Senator. I'm just really trying to look back through the redrafted clause 51 that deals with the referral of complaints to see the remit of the PBCC. But your point is well taken. Thank you.
Ms. Gordon-Jones, can you summarize the decision or summarize what we're to decide on?
I think the question has not been answered in relation to the PBCC being inserted. So that is, I know member Senator Brown was saying that the decision was taken, but just to ensure for the record in terms of the inclusion of the PPCC under Clause 66. Senator Brown. Yes. I mean, Gail, sorry. Sorry, Senator Gail.
be on the record. All right, so members, we will pick up at the next meeting on clause 66. We'll continue the discussion there. We're asking our technical persons to continue to look at this to help us decide if we just remain with the public institutions or we broaden that remit to include private, right? And once we are past clause 66, then we will start again on subclause 67(1)(a) through clause 71, subclauses 171, 1A to C, to get those decisions ratified. And hopefully, as well, we'll be able to move on to the remaining clauses up to clause 85, I believe, clause 85. And then we have first, second, and third, fourth, fifth schedules. All right? Yes.
When I look at the report and the remaining clauses, there are a number of comments that are made that is going to require some in-depth deliberations. Not a question of just reading through a report and recording that report as part of the proceedings. And there are some areas to which we have not yet agreed on. And this has been a very extensive deliberation in going through this proposed legislation. I believe there's another meeting that is already being scheduled. But I would want to encourage and recommend that we set aside a particular day when we can just mop up all those outstanding matters and go in depth in going through all the comments that are made in relation to the report. But in light of that, I would like to suggest strongly that all the members be present for us to be able to conclude these deliberations. And when I say present, I would hope that wherever we're going to meet, that we would have all members in attendance, as best and as practicable as possible. Because I do know that, members do have some concerns in relation to what is being proposed and what is being deliberated. So I'd want to suggest and strongly encourage that approach.
All right, members and our technical teams, we will conclude here for today, and we will set a date for the next meeting, June 13th? Yes, okay, 2 p.m. Huh? Okay. A reminder, the next meeting will be June 13th, 2 p.m., a Thursday. All right. Any question? All right, we ask for adjournment. Thank you, Member Gale. Seconded.
I'll second.
All right. Thank
All
you.
right. Thank you, Minister.
All right. Thanks a lot.